Okay, and I'll let you get us started because I'm pulling up the agenda and I don't have it quite up in both places. So go ahead.
Okay, so I have just a couple of logistical things to check in about. First, the materials that went out 2 weeks ago, I think it was. One of the things I had asked was if you are not listed on a small group, but would like to be, please let me know. I heard from the OJD folks, but if there's anyone else who wanted to be added on to any of the small group conversations, um, just let me know and I can throw your name in there and I'll update that document before the next meeting. And so I know that there were some folks who were not able to attend the last meeting in November, so I wanted to give people an opportunity to chime in. So that's in your materials for today. And then the second thing I wanted to check in about was um, outreach. You all had flagged that you would love to have someone from DOJ and some criminal defense representation. I've reached out to a couple folks through the criminal defense side and DOJ again, and I will let you know what I hear. We're still moving forward on that, and I will keep people updated. So those were my two logistical things.
Great. Let me see. I think I'm getting this up now. Here it is. Okay. So we've had a couple of small group meetings about the waiver of undertakings on appeal. And I feel like we made some progress on that. Um, and I'm gonna just ask, I know that Heather provided some feedback. I know that Jim has been kind of tracking our movement. And I know that we all got some input from um, a couple of the Justice Department or Justice Court judges. Um, and I guess I would ask Jim, if you can kind of bring the whole group up to speed on maybe whether we have a proposal for the group to consider today, and if so, what it might look like.
Um, okay, thank you, Judge. I think the net result of the meeting is that the consensus of the group um, was that there was no need to make the kinds of changes we were talking about, either in terms of giving either the Justice Court or the Circuit Court the authority to waive or reduce undertakings. There was I there are certainly members of the group who favor giving courts such authority, but I would say I think the majority view was that courts need not have that authority. And the other major issue was whether, assuming that we leave it as is in House Bill 2460, the authority of the Justice Court to set the terms of either an undertaking for costs or a supersedious undertaking, whether there should be any opportunity for circuit court review of the Justice Court's decision. And the consensus was that no, we should not. Again, recognizing that Heather and others may actually favor that, but some or all other members did not. Um, the only conceptual consensus I heard is that everybody agreed that whatever procedures we think of to implement laws and protect the rights of the parties should, to the extent possible, should be spelled out in the statute so that there's no misunderstanding on either the part of justice courts, circuit courts, or parties as to what those procedures are. But notwithstanding consensus on that principle, we couldn't agree on any changes to the current law. So I think as it stands now, there's no consensus to propose any changes to current law.
And thank you for that, Jim. I think that one of the things that we talked about was whether it made sense to spell out what the Justice Court does. And also there was a question about whether we could align the Chapter 19 timelines with the timelines that for other appeals from Justice Court to Circuit Court. And challenges to like an undertaking so that things were aligned. And I don't remember if we came to a consensus that that should be changed in statute or if that was something that should remain fluid.
Well, that was something that I certainly advocated for, but I know there was a question whether we spent most of our time focusing on other issues. I ultimately didn't hear anybody else speak in favor of that. So my ultimate conclusion is, at least as of the end of that meeting, there was no consensus on that issue either.
Mm-hmm. Okay. And Heather, I know you had some observations about the process, and I guess the question I have is whether there's anything that we need to tweak in the legislation, or if this is something that could be referred to someplace else, and if there is a someplace else to address some of the concerns that you had with respect to the sufficiency of being able to appeal an undertaking in the circuit court.
Thank you. Yes, just as context for everyone, the feedback that I'd received from other legal aid practitioners is that there have been concerns with clients that we've worked with around undertakings, and there not being a process where judges had discretion to waive or reduce undertakings related to costs. And the current legislation does not address that issue. And I was understanding, and I see Judge Kidd is here, so, or Justice Kidd is here, so I don't need to speak for him, but I was understanding, where we are seeing processes, it's kind of courts taking it upon themselves because there's a sense that there should be some sort of process in place. But it's not really clear to parties or necessarily to judges what that process is, and it's definitely not streamlined across the state. And so my sense from others I've talked to is that there is a need for some change here, if it paralleled Chapter 19, that would address our concerns. Chapter 19 deals with the undertaking, waiving or reducing the undertaking related to costs when there are appeals out of circuit court. My understanding with the cost is that this wouldn't create, initially we talked about there being sort of a concern around how that works with the timeline, because the bill had created an expedited timeline for certain cases, FEDs. And of course, we're talking about things much broader than FEDs, like any civil cases arising from justice court. So that's important to remember. But even with the FED process, I don't think there's an issue here, because the appeal can proceed even while the undertaking is being resolved. That's how it works with appeals out of circuit court to the Court of Appeals. An undertaking is not a jurisdictional issue. So the parties can have motions around it while the matter proceeds. And the higher court only takes it up if the other party actually objects, there's actually an issue. So that was some of the feedback that we had regarding this, and I appreciate the discussion.
Thank you. And then I got something from Anna McCormick today. I think it looks like today. And Anna, is Anna on the phone with us?
Yes, I'm here, and
Okay.
I apologize for the dreaded email 2 minutes before the meeting.
Well, I thought I'd give you the floor so you could talk us through that.
I really had hoped to get it out sooner, but I figured getting it out at all was better than not.
Yeah.
It was really just my stab at sort of taking all the hard work that Jim had done in creating some, proposed resolutions to the concerns and trying to harmonize it with, the existing statute. And when you get a chance to look at it, really, I kind of conceptually divided it in between the undertaking for costs and to stay eviction of a money judgment, which are kind of conceptually distinct from the bulk of the conversation seems to have been dominated by discussion of FEDs. And I was, appreciative of the comments saying there's more to this. And so I kind of dealt with, how to maybe treat them slightly differently, and provide for a mechanism to, allow an objection to the sufficiency of undertakings for costs and to stay execution of a money judgment and a process for that, and then create a separate potential process for what I'll call supersedious undertakings to stay execution of an FED judgment. You'll note that the main blank I left was in the FED part because, as Jim pointed out, there didn't seem to be a real consensus about whether we should provide for review at all, much less the terms of it. And so I kind of left that part blank. And the only comments I made were that, I do agree that the timelines should kind of be aligned, but I'm not in favor of stretching the timelines to reflect ORCP, or I'm sorry, ORS 19, but rather reduce all timelines to conform more to what was originally conceived in the FED aspect of the statute. And that's simply because ORS Chapter 19 timelines are based on an appeals process that takes 1 or 2 years. And because this is so compressed back in FED world, it's compressed into a much shorter time period. My overarching concern is making sure that the process, if we create a process for appealing the Justice Court's decision with regard to an FED undertaking, that it doesn't just swallow and create a de facto stay until that trial. Because again, that's the entire purpose of the undertaking, is to maintain the status quo. And so if we are going to create such a process, I do think it has to be a very rapid timeline. And that's kind of all I'll say. But again, I apologize. I'm sure no one really has had time to look at what I sent out. So.
Well, go ahead.
Judge James, I just want to, I see Heather in front of you, but the language that Anna sent out, it didn't go to the whole group. So I'm going to put it in an email and it will go out right now.
Okay.
Oh, yeah.
All right.
Sorry. I think I just replied to existing
you're fine.
emails in what I now understand are a smaller group.
Okay. And I'll speak to your what you sent out, Anna, in a second. And then Heather, you have a question. You have a comment.
Just that I'm looking, well, 2 things. First, I'm looking forward to reviewing the proposal, and I agree, like sending it now better than not sending it, and I haven't had the chance to review it, so I'll look forward to that. And just wanting to like underscore for the larger group that maybe hasn't been tracking the conversation as closely, that we're talking about 2 parallel issues here. One of them is the undertaking for costs, and then there's the undertaking that would be to stay the judgment. And so, with an FED case, to stay the judgment, the tenant would need to be paying, the rent, for example, in order to stay the FED. And so there's might be a concern around landlord collecting their rents while the process is underway. That's one issue, but then there's the issue about, the costs of the litigation itself, and so the concerns there with with waiving or reducing while the FEDR proceeding are perhaps less of a concern, because even if the FED case proceeds, if there is a judgment at circuit court resolving it on an expedited timeline, the prevailing party will be entitled to their costs regardless. And so then this undertaking for costs will no longer be important. And so I think it's just important to remember that we're talking about two different types of undertakings, and what they mean might vary, like how we deal with them maybe should be different depending on the case.
I agree, Heather. And I think in our small group, what we talked about, it seemed like there was not a consensus to move forward to address an appeal of an undertaking for rent in an FED case, but there was interest that seemed to be a consensus of interest in devising language to address the waiver or stay of an award of costs of the litigation, costs from the Justice Court pending appeal to the Circuit Court. And so it might be that that's the piece that we can accomplish. I think that's where Anna's memo, you'll find Anna's memo is trying to make an inroad there. And so what we may want to do, and I don't know, Justice Kidd, if you want to jump in here, but what we may want to do is have the whole group look at this email, at the memo from Anna, and then for our next meeting, we could make a decision. Is this a language that we would like to adopt? Is it language we'd like to recommend to the commission that the statute that change the statute to address at least that significant issue and try to make it more consistent with the rest of the statutes that we tried to align?
I think that I agree with my colleagues that there's a difference. And I'll just say that the costs in an FPD case are so small, right, in comparison to the other thing, that honestly, I don't think any of the justices actually even consider the costs as part of like that analysis. It's the other one just swallows it all up in my experience and in my talking with the colleagues. So I think, if we want to create something about costs, I think that's fine. I think that will have a very small effect on what actually happens, because what drives the train really is whether the person can afford rent going forward and trying to protect the landlord's judgment in status quo there. And the rest of it's just kind of an afterthought, really.
Mm-hmm. And I don't know if that afterthought is also an afterthought in other cases that are being appealed from Justice Court. So if we looked at it as more of as a universal fix, is it worth making that fix?
Well, okay. So for some context, my filing fee is a whopping $38, and my sheriff fees is $50. So the very most common cost I have is $88. Or maybe if there's some copy costs in there, we approach $100. So it's almost not worth talking about if I'm being honest. But because the jurisdictional limit is so small that people do not spend a bunch of costs on these cases.
Okay. All right. Jim.
If I may speak to that issue.
Okay.
What we're talking about here is not the Justice Court's costs, because those will be incorporated into the judgment. What we're talking about here is waiver of the undertaking for costs on appeal. And I think the only recoverable cost on appeal is the respondent's circuit court filing fee. And I think that's up in the 300s now. So we are talking about a little bit more money, but still, you may be right that in the overall scheme of things, especially if we're talking about undertakings for money judgments or recovery of property in Justice Court, as I recall, the jurisdiction of the Justice Court is up to $10,000, or is it $15,000? So you could have a judgment for $10,000, and that is a very significant sum of money for many would-be appellants to post an undertaking for that sum of money in order to stay enforcement of that pending appeal to the circuit court.
I stand corrected. I was totally wrong about what cost we were talking about. Thank you.
I also think even when we are talking about a smaller number, for the people who might be applying to reduce or waive it, that could be a significant barrier. And so it's still worthwhile to talk about, even if it's not, the rent piece that could make the process more accessible for folks.
All right, that's really helpful. And so what I'm going to do is kind of the same thing. I'm going to suggest that we all take a look at this, look at Anna's proposal, and see if that gets us to a place that we can agree and that we can send it forward to the commission. And if not, then we've done our work and we've done our due diligence. But if we can, and if it helps make it more understandable for people who are engaged in this litigation in the courts and in the prospect of an appeal, sometimes it's like, we might think this isn't going to make a big difference, but it might be if they know there's a process to seek waiver of an undertaking, that may be the difference between whether they would want to appeal and whether they wouldn't want to appeal. And that's, that's a door open, that may be what we want to be able to allow people to have. So I really appreciate the work on this. And if you will take a look at Anna's suggestion, and if you have any feedback in the meantime for Anna or for myself or Amy or any of us, feel free to shoot an email to all. And I really do appreciate it. So unless there's more on that topic, I don't know, Amy, if there are other, I sort of jumped the reports from other small groups and I apologize for that. So if you want to go back to that, and then we can go forward to the waiver or to the provision of notice.
So Jim had his hand up, so I want to let Jim jump in before.
Thank you. I don't know if I also have not had a chance to read Anna's memo. I don't know if it addresses the issue of circuit court review of a justice court's decision establishing the amount of the undertaking, which in FED cases would be the amount of rent that would be paid into court. But I did want to bring to the group's attention that there's a long line of Oregon cases holding that every court of law has inherent authority to issue orders as necessary to either preserve the court's jurisdiction or to prevent irreparable harm to a party. Pursuant to that authority, appellate courts have the authority to stay enforcement of judgments. Those cases also hold that the legislature has the right to regulate how courts exercise that authority, and the legislature has done so by adopting statutes requiring supersedeas undertakings, establishing the rules about what security a party may use, qualifications for sureties, providing a process in the initial trial court for the trial court initially to make that decision, and with respect to appeals from circuit court to the Court of Appeals, explicitly providing for appellate review of those decisions. In my view, circuit courts have inherent authority on appeal from the justice courts once the notice of appeal is properly served and filed. It has inherent authority to review the justice court's decision regarding the undertaking, and that a party may invoke that authority by filing an appropriate motion. Because the circuit court, I believe, has that authority, I think the statutes ought to make that explicit so that all justice courts and all circuit courts and all parties, particularly all pro se parties, know that the court has that authority. I recognize that, particularly in FED cases, that authority may be not particularly meaningful because of the speed at which those cases move may mean that the circuit court really doesn't have any meaningful time to address that issue before the case is already heard on its merits. But at least in other kinds of cases, appeals from money judgments and judgments for the recovery of property, that may be a meaningful thing, that the circuit court could hear such a motion before the matter comes on for a de novo trial. So for that reason, I would favor Heather's proposal that the statutes be amended to make explicit that the circuit court, on motion of a party, would have the authority to review the justice court's decision on the on any undertaking decision.
I guess that begs the question of whether you're suggesting that they should also be able to stay enforcement while they hear that, which then goes against the expedited process of in an FED case, as you used the example.
Well, I think the case law is clear that the circuit court would have that authority. Now, whether it should exercise it or not is a separate question. And I think most judges recognize that the landlord has filed the FED. There's been an opportunity for a trial in the trial court. The landlord won and the tenant lost. And so the tenant would have an extraordinarily high burden to show that the tenant should be allowed to retain possession of the premises without paying into court the amount of rent determined by the justice court. But there may be instances where, let's say the rent is $1,000 a month and the justice court adds something else to it, recompense for damage to the property or previous unpaid rent or attorney fees. And so there may be in a case where, as a matter of law, it appears the judge is wrong, and provided that the tenant is willing to pay at least $1,000 a month into court, perhaps the tenant should be entitled to a temporary stay. Likewise, if you have a situation where the rent is $1,000 a month and the justice court determines it should only be $200, maybe the landlord should have the right to get review of that issue too. Again, recognizing that the speed with which FED cases are heard, probably in 99% of the cases, it's going to be moot. But in other kinds of cases, maybe not. Particularly if you have a case involving habitability issue, those kind of trials where you call engineers, or you call plumbing specialists, or you call housing specialists, perhaps those hearings get set over, and so you would have time to hear such a motion.
Jim,
I see.
my memo did kind of have a little placeholder for that, because I thought there might be further discussion. The only thing, and this is really just a query, because the thing that to me would sort of provide some assurance that the appeal of the supersedious doesn't just swallow the entire supersedious would be placing some sort of timeline for circuit court review. But I don't know what the circuit court's perspective on all of a sudden, having this very accelerated timeline. You'll see that as kind of a placeholder, I just thought, could it provide that the circuit court would have to set a hearing on the objection to this,
Right.
The appeal of the supersedious, the justice court's decision within a very short time period. And then if they don't, the justice court's decision stands. I was trying to come up with something that kind of provides an opportunity, but makes sure that it doesn't effectively mean that a supersedious just doesn't mean anything. So, food for thought.
Okay, thank you.
And Jim, I just had one other question. The cases that you mentioned, are any of those cases FED cases?
I don't believe they are, no.
Okay. Right. Okay.
James, if I could be heard just really quick.
Yep.
Um, I share Anna's concern about that process swallowing things. If our worry is that the justices are going to do an incorrect number, the very best way to do it is just to tell us what to do, right? Because for those of us who are not lawyers, right? If the statute just said the number shall be the market value of rent and shall not include past rent, that will take care of all of these problems. And I promise, like, the school teachers and postmen who are otherwise being judges over there would love to know exactly what to do.
That's a really good suggestion. Okay. Food for thought. And I think with that, we can move on. Amy.
Okay, so the next thing we have we haven't had any other small groups meet yet. The next thing we have on the agenda is the question that came from ODAA. And Monty, I might throw it to you.
Certainly. So Amy and I have met, and I've been looking at the House Bill 2460 and also talking with ODA, trying to get up to speed. Bottom line, the concern was the notice requirements in House Bill 2460, whether it requires notice to the district attorney's office when the DA is not involved in a justice court case or municipal court case. My understanding is, of course, that 2460 has already been passed. It's in the process of being codified. But I did reach out to ODAA, and right now, as of right now, it sounds like no district attorney's office is involved with the municipal court appeals. And then as for justice court, there is about 9 or so different district attorney's offices that are involved in justice courts for different levels. For example, in one county, well, I'll just name the counties that have some involvement in justice court or reported: Harney, Baker, Gilliam, Tillamook, Lynn, and that's it. So actually about 6 or 7. So in light of that, and then
Canyonville,
looking at
for sure. Canyonville also does criminal cases.
Canyonville does? Okay.
Mhm.
So Grant County,
No, it's like the county that has
Canyonville.
Roseburg in it.
Douglasville, or Douglas
Yeah.
County?
Yeah.
Sorry, I was thinking Canyon City. So with that, at this point here, I haven't heard any further concerns through ODAA about what's been codified. I anticipate continuing to reach out and seeing if what's been passed causes any additional issues. But at this point here, I have nothing further for the group.
Okay, so Monty, in those communities where they have DAs who are involved in the appeals from justice court, are the appeals being served on the DA?
I didn't hear feedback on that part. When I reached out through ODAA, it was just simply, hey, who's involved with the
Mhm.
justice courts? Under 2460, in my read of it, there's about 7 or 8 different provisions referencing district attorney and service, but it's in conjunction with also serving the party's attorney, the opposing party's attorney.
Right,
So my presumption would be that if the DA's offices are involved in the justice court matters, they would be getting served in
as
some
the party's
respect.
attorney.
Correct. Either as the party's attorney or under that extra little subsection that says, well, if you didn't serve the DA under subsection 1, serve notice in these circumstances.
Okay, so does that sound like we don't have a problem that we need to fix?
Not one that I'm aware of at this time.
Well, that's good news.
If I become aware, I will definitely bring it to the group's attention. But at this point here, I would ask no further discussion just because it's already been passed,
Uh-huh.
given the different involvements.
Okay,
See what happens.
all right. That sounds good to me. Amy, do we have other issues that we want to start getting active on as we move forward?
So the next issue that we had on our calendar was to start talking about court of records and justice courts becoming courts of record. And that was going to be a conversation that would begin at the January meeting. So I do have that list of folks who have expressed interest in that topic. And what I can do is set up you know what, I'm having a moment. I can't remember when our next meeting is. Just give me a quick second. Try and set up an initial meeting before that January meeting. Hold on. It's a little complicated with the holidays, but but we can do that. And I've now frozen my computer. So I will don't have that in front of me right now, but I can. But we could do that and set that up so to have that initial conversation. And to get that started. I know that Justice Kidd had a bill last session that dealt with some of these issues. And we've got that. So there is some language actually already drafted. And also I know from that the codification of the new ORSs is creeping closer and closer, and it's in the pipeline. Jessica, I'm looking at you and crossing all my fingers and toes, but it sounds like it's coming in that direction.
Yeah, if you needed confirmation, I think everything has already been sent to the printer. So, yeah.
Does that sound like a good plan for folks to have an initial meeting before the next full commission meeting so we can kind of talk it through? And then we can talk about the FED, Anna's language at the January meeting, and kind of wrap that up. Sounds like nothing from ODAA on the service, which is good. And then we'll just start the conversation on court of record.
Sounds good. That sounds good. I was just looking to see because I had our schedule in front of me and I'm also like losing it. So just
Heather, you had your hand raised.
Clarifying question. Am I right in my recollection that the proposal regarding courts of record, that's dealing with justice courts, or do you anticipate that it's going to apply to municipal courts as well?
So
I'm going to let
courts,
Justice Kidd answer that.
municipal courts can already become courts of record. So that's a statute that's maybe 10 years old. And so my proposal would be to permit county commissioners to elect to make their court a court of record.
Right, because this was just having to do with that that restriction around distance from a circuit court. And okay.
Exactly.
Thank you.
okay. I'm just looking to see if I have this. Okay, I'm not finding it. So Amy, you will tell us when our next meeting is, and you will also give us some options for a small group meeting.
Yes, and what I'll do for the small group, just because it's the holidays and our next meeting is on the 21st. I found it. My computer started working again. What I'll do is I'll send it out to the whole group. I do have a list of folks who have said, hey, I'm definitely interested in this, but I will send it out to everyone on my listserv for this group to say, we're going to pull together a small group. And if you haven't had a chance to reach out to me and let me know, here's your opportunity.
Great. Right. And I just saw that Juliet has indicated that she would like to be added to that group. So.
Perfect.
All right. Well, if there's anything else for the good of the order before we adjourn, I want to thank everybody. I want to wish everybody a very happy and healthy holidays, whichever ones you are celebrating. And then we'll have our meeting of the full commission for any commission members will be this Friday.
And sorry, so sorry, I want to raise one other thing and I will send out an email. This Friday, we have a program committee meeting. Many of you have probably already received that notice, but if you haven't, you'll receive the notice. All the materials are posted on the commission's website. And for those of you who are new to the working with the commission, a program committee meeting is for the full commission to consider additional projects. So this right now at this December meeting, they're going to be looking at simple estate affidavit criteria. If anyone's interested in that, let me know and I can send you the Zoom link and you will get an email about it before the end of the day. So I just wanted to flag that. I forgot to put it on, talk about it earlier.
Okay, everyone, have a great rest of your day. Thank you.
Thank you.